the contents of this paper today.
Thank you so much, Director Ed Felton, for the warm, kind introduction and the welcome. This talk will be exclusively in English unless I forget some words and then have to throw in something else. Thank you to the CITP and Jean Butcher for including us today in the talk. Last month, the U.S. Court of Appeals for the Ninth Circuit declined to vacate a panel's ruling to maintain an injunction against President Trump's first travel ban. What's particularly salient for us and for our paper was this lengthy criticism directed at the president by a judge, which Slate labels a, quote, one of America's most conservative judges. So here you have one of America's most conservative judges criticizing the president. And he ends his judicial opinion, Judge Bybee, Jay Bybee does, with a sharp reprimand, criticizing the president's attacks on the district and circuit court judges. And here I'm quoting Judge Bybee. I wish to comment on the public discourse that has surrounded these proceedings. The personal attacks on distinguished district judges were out of all bounds of civic and persuasive discourse. It does no credit to the parties to impugn the motives or the competence of members of the court through ad hominem attacks. Such personal attacks treat the court as though it were merely a political forum in which bargaining, compromise, and even intimidation are acceptable. The courts of law must be more than that, or we are not governed by law at all, end of quote. While this rebuke was actually expressed within the courtroom walls, right, within an actual decision, it feeds directly into the theme that occupies us today, cyberintimidation and the proper limits of judicial expression in the digital age. It stands to reason, actually, that the only explanation for Judge Bybee going through this tangent in his judicial opinion is because he lacked a better alternative to express the judiciary's serious and legitimate concerns with guarding individual judicial institutions and ultimately democracy itself from the unique form of disrepute that social media can impart. So this opportunity to harm in a new and qualitatively different way. So it's, as you all know, misinformation, disrepute that's instantaneously visited upon individual judges and then are very difficult to correct on the internet. As the Supreme Court's most recent nominee, Judge Gorsuch, labeled these types of critiques, quote, demoralizing and disheartening. And that, I think, is very strong language from a judge. Cyberintimidation, as you know more generally, and as the New York Times described as a pernicious form of harassment, here I'm quoting the Times, often but not exclusively aimed at women, right? So I'm going to highlight the particular impact on female judges and members of vulnerable minority that is attracting particular attention. It's presumably, this type of intimidation is presumably on the rise in the judicial context. Why? Because technology and social media in particular, this perceived anonymity and other characteristics, facilitates dissemination and intensifies not only the frequency of attacks, but the nature of the attacks and the impact on democratic discourse. It has a particularly disheartening impact on what Spiesel has called the culture of law itself as an organizing institution of our common lives. So it's never been a secret that the public is ill-informed or uninformed or underinformed of the role of the judiciary. One judge has lamented, and this is before digital media, the judiciary's traditional response to misinformation or criticism in the media, and this judge here that I'm quoting is referring to traditional media, has proven ineffective in preventing decline in the public trust. So again, a fortiori with the particularities of social media. So what we're going to try to do in this very short period is highlight parts of a paper that my co-panelist and I wrote last fall and is under review for publication. It's basically a call to engage on the following emerging issues. So should the rules of ethics, and here it's from a comparative perspective, we're looking at the paper at various jurisdictions, should the rules of ethics pertaining to judicial silence evolve in keeping with the digital age? Right? Other notions certainly have and are in the process of. And if so, in which direction? the ultimate answer is left to our common reflection, but certainly this is something that must develop over time. And our main argument is that cyber intimidation, shaming, and unfair critique of judges in the digital age is not only increasingly widespread and problematic in itself, but creates a distinct predicament for judges. And why is this a distinct predicament? In a word, because the rule of silence, as my co-panelists will discuss in a minute, is the widespread ideas in many jurisdictions, particularly in common law jurisdiction, less so from, I come from Quebec, which is a civil law jurisdiction, and civilian Europeans have a different notion of judges. But in many common law jurisdictions, the idea is that judges should speak only through their judgments. And we see here the example of Judge Bybee, who is speaking through his judgments, but is offering a tangential rebuke, which one can only assume he felt he must in light of otherwise this imposed silence. So is the ethical rule of judicial silence in its original form still justified, given the challenges of the digital age? And the argument here is that it must be refined. So I'll basically overview the phenomenon of cyber intimidation, its specific impact on judges, its challenges to the judicial branch, and my colleague will elaborate, as I said, on the ethical rule of judicial silence and its justifications, its traditional justifications, and will show that the rationales no longer necessarily support such a stringent and uncompromising rule today. So perhaps we might look at the easing of such ethical principles given the medium, right? Given its particularities. It's very difficult to close our eyes to the way that communication has changed, which we're all familiar with, but we haven't necessarily, or the literature hasn't really exposed how that applies to the digital age. And then he'll turn it back to me for a really quick conclusion, assuming there's a minute left, and we'll open the floor for questions. So again, we're all familiar, even though it bears repeating, with the particularities of internet speech, instantaneous reach, instability, problems of authentication, absence of gatekeeping, error correction, and the temptations of anonymity, to name a few. But compounding a problem, I should say, this comes at a time, so this criticism, this cyber intimidation, this shaming of judges on the internet comes at a time when verified and verifiable facts are offered on platforms alongside alternative facts, quote, where fake news, quote, or fake history are insidiously and easily confounded, right, even by educated individuals, with verifiable historical record on the internet. On a separate piece, I actually looked at judges themselves relying on Wikipedia. So it's tangential, but only to show that obviously educated, highly respected judges are borrowing internet sources. And it's very difficult for them, a fortiori for everyday people such as ourselves, to distinguish between what are legitimate sources and what are internet sources that may be providing unfounded information. We certainly see it in the science context, in the vaccine context, and so on. So the medium is, the platforms are important. Platforms, as you all know, use analytics to predict what will maximize engagement, right? So if you have that, it in turn pushes hateful speech, punitive speech, virulent speech, even racist speech front and center. It shapes people's views, but more importantly, it may distort people's views. So if you already harbor certain prejudices and your source of information are these questionable sources, for lack of a better word, and the platforms realize that you are susceptible, or that you are enjoying, or that you are passing on this type of information, they will saturate you with it. So think of that, obviously, in the judicial context. Daniel Solove, who has written a lot on privacy, has said this outside the judicial context, but he said, we live in an age drenched in data. On the internet, we constantly live in a twilight between fact and fiction. So on the heels of gruesome acts of violence on Facebook and racist incitement featured alongside advertisements for reputed corporate giants on Google, even these American internet giants, who were generally aligned with the notion, the First Amendment notion of speech, that it's not their place to limit speech and that more speech is always better, they've sort of are pushing back with announcements by the larger companies in the past few weeks that they now wish to take part in curtailing speech that, and I have extracts of how they defined it, but it's somewhat lengthy. So platforms, and this is a tangent, but I think it's important, platforms are thrust into what can be defined as a quasi-judicial role. These platforms become arbiters of speech. And in most jurisdictions, such as Canada, constitutional values do not apply to non-state actors. So this is very little accountability, very little transparency, and outside of the normative framework, which can lead to absurd results. If we had more time, I'd go on and on about how a Syrian cookbook was banned from one of the platforms because the algorithm had seen the word Syria and thought that it may be harmful, or your famous war child, who an algorithm had, and I believe it was in the case of Facebook, had censored because the war child was unclothed. So this is a different topic, but one that I think ties in because parallels can be drawn to inform a discussion of how that ties into the judicial context. So must the prohibition on extrajudicial speech in light of this backdrop, as Canadian Justice Gagnon suggested, quote, give way if a failure to respond to attacks could undermine the authority of the courts, if it perpetuates ignorance or unjustly humiliates individual judges and their family absent due process? Must it cede to other democratic values in order to convincingly negate the rationale set forth? And this is, end of quote, my poor translation from the original French. But the idea is a questioning of whether the rationales still apply. And you've seen that in the past few months, there was a panel that we had in New York at an International Legal Ethics Conference discussing the phenomenon. And that very day, U.S. Supreme Court Judge Ruth Bader Ginsburg had made comments outside the courtroom, speaking of a presidential nominee. And this struck the media as out of character for a judge. So this is a recurring phenomenon, and we see in Canada again, the Chief Justice, Quebec Chief Justice, wrote an editorial in a leading newspaper saying perhaps we need to put into question the perspective that has been the dominant one. Dahlia Lithwick suggested that Justice Bader Ginsburg's comments were apropos, and she said, by speaking up for a judicial branch that has absorbed one blow after another in recent months, Justice Ginsburg did nothing but level the playing field, end of quote. So again, this is especially true of digital media. I have many examples, but time is running short, so I will leave you with one tweet that I edited very heavily because it's extremely distasteful. But the reason that I will mention at least parts of it, even though it's very unpalatable, is because there's a gender dimension to it that can't be ignored. And I think if women or members of vulnerable groups wish to be attracted to the judiciary, right? So a question of who do we attract to judiciary? Is it only those who have no life experience, no digital baggage? Who amongst us has no digital baggage? And the fear of being exposed or the fear of being vilified may be particularly chilling for those who belong to vulnerable groups or to women who, as we know, are victims of cyber trolling. So here's really heavily edited version of this tweet, which is PG-13, I think, but examples abound. Targeting a female judge. So the tweet goes, it's judges like this that should be taken out back and shot. Why waste ammunition? Wood chippers get the message clearly. I suppose there's a special place in hell reserved for that horrible woman. Send her through the wood chipper. Again, heavily edited, but very gendered, right? Tweeted and retweeted. And we had a panel at the University of Ottawa about appointments and whether individuals belonging to vulnerable minorities, individuals who have who are members of cultural communities or other vulnerable communities would be dissuaded from even applying to the judiciary for fear that they would be specifically targeted. Tweeted and retweeted again. So I will end my part on this. In an age where anyone risks humiliation online and an industry has sprouted to facilitate online reputation management, the right to be forgotten, judges present an especially thorny case because this is an era where a proverbial lie, as Mark Twain said so many years before social networking, can make its way halfway around the world before the truth even has a chance to put its boots on. So that's a quote by Mark Twain. Let's think of it in today's age. Shaming, as Posner has said, is the antithesis of law. No due process. He says, instead, people react instinctively and harshly. And platforms will, through the mechanism, create exponential value. So special masters of the roles, Dyson, who by his title you can see is British, and has warned against this as well. So it is a problem essentially of misinformation taken to different dimensions, qualitative and quantitative. And I will end on this. And my colleague will continue with the rules on judicial ethics on point, and we will see whether it is time to rethink these rules in the digital age.
Okay, thank you very much. It's a pleasure being here. Also, thank you for the words of introduction. As mentioned earlier, I will focus on the judicial silence rule. Being a judge, I don't have the privilege now to be silent, right? But I will try and say a little bit more about the rationales behind this rule. And it is indeed very interesting that, taking into account this background that Karen was talking about, cyberintimidation and alternative facts about judges, we do find public officials, the judicial branch, being, as an ethical rule, silent, without having ethically the possibility that most other public officials do have, not to mention just general public, to react and to comment in cases there is cyber intimidations or false fact just out there. And that's an interesting phenomenon, and it exists in many other jurisdictions, not only in the US, in the common law, civil law traditions. So I want to speak a little bit about this rule of judicial silence, the rationales for this rule, and whether these rationales are strong, are convincing today, taking into account this reality that we just described. If you look on American law on the judicial silence, the Code of Ethics, the ABA Model Code of Judicial Conduct for 2011, states as following, and I quote, "A judge shall not make any public statement that might reasonably be expected to affect the outcome or impair the fairness of a matter, pending or impending, in any court, or make any non-public statement that might substantially interfere with a fair trial or hearing," end of quote. And that provision was adopted by many states. When it comes to federal judges here in the United States, we have the Code of Conduct for judges, and I quote again, stating that a judge should not make public comment on the merits of a matter pending or impending in any court. The prohibition on public comment on merits does not extend to public statement made in the course of judges' official duties, to explanation of court procedures, or of scholarly presentation made for purpose of legal education, end of quote. Now, there are other jurisdictions in which the rule of judicial silence is even narrower. As mentioned, the Israeli code is stating, and I translate, that the judge speaks throughout decisions and verdicts and judgments. Judge is not interviewing and is not transferring any information to the press. So that's the rule in many common law traditions. And what are the rationales for such a rule? Such, I would say, even an exceptional rule when even it comes today to public officials that are there on social media on a day-to-day basis. Well, there are several ones. The first one is judicial image. It is quite often said that a judge's image is one that is not reacting, that is not commenting even to critique of judgments and the judge's behavior, be it even wrong or false. The idea here, again, is that judges should be more tolerant than any other public officials, and in order to preserve the image of the judge herself and the judicial branch in cases where other public officials would react and would comment, judges who should avoid doing so. There is also another reason coming in here, saying that judges should not disclose too much about the deliberation or the way they thought about a case, other than the reasoning already written down. Some scholars compare it to that judges should not disclose how the sausage is being made, in a way. So that's a first rationale. A second rationale or reasoning for the judicial silence rule has to do with judicial independence. Here, this comes from the law of judicial judge recusal, and the idea is, of course, that judges should be independent, that the judiciary must be independent, and therefore, if judges need to be independent, they also need to show that they are independent. Now, if a judge is commenting or reacting to even false allegations or unfair critique, they are showing by this that they were affected. And therefore, the idea goes that if they want to show that they are independent, they should remain silent. Moving on to another rationale, this is the one that is, I think, more significant. It has to do with appellant procedure. A court decision, be it a judgment or any other decision, is normally subject to an appeal. Now, the appellant court needs to know exactly what were the reasons for the judge to decide the way she decides. And these reasons should be reflected in the judgment itself as it was written. Now, the problem is that in cases where the judge needs to react or to comment on a critique, or social media or cyberintimidation, they might add reasoning to the original judgment. And here there is a problem in terms of appellant jurisdiction and appellant procedure. How will the appellant court know exactly which reasons were behind the judgment? Are these ones the ones that are written there, or adds-on that came up later? Now, adding further reasoning to the original judgment may also cause a problem in terms of public trust, be it the litigant or general public towards the decision as it was handed, because people might ask themselves if these are further reasonings that did not appear in the original decision, were they part of it? And if they were not, are they post explanations to the original decision that were not there originally? And this, of course, can be problematic. Another rationale, again, a reason for the rule of silence has to do with interpretation. Sometimes judgments and decisions given, handed down by judges need to be interpreted. How do you interpret them? Usually you should use the same mechanism and same theory of interpretation like any other law. You should do this by reading the decision itself, but not by asking the judge what did she mean when she wrote this, and or when he wrote it. And here comes a problem once a judge is adding reasoning or explaining the decision later on. How should we interpret the original decision handed down? I think perhaps the most significant reason behind the rule of silence has to do with the law of judge recusal, or judge disqualification. It's not surprisingly the rule I was citing from the ABA code has to do with judicial conduct and with the idea of fairness. We do want to avoid situation in which judges, by extrajudicial speech, pose basis for motion of recusal. And this might happen quite easily if judges are referring to cases that are pending or impending in front of them, especially if they might cause a subjective or even an objective appearance of bias to the parties in that case. So that's a major rationale. And if you add to it the fact that quite often it might be that judges, when they will comment on cyber intimidation or shaming or any other form of critique outside the courtroom, this might take the form of an ex parte communication, which is problematic by itself when it comes to judge recusal. Because normally anything that is happening in the courtroom, open to the public, but known and clear to the parties is one thing, and everything that is happening outside the courtroom, ex parte communication that is not known to the parties, is not publicly known, is causing a problem in terms of ethics and in terms of judge recusal. The last rationale, quite known about trying to explain, let's put it this way, the rule on judicial silence is separation of powers. Here the argument goes that judges have a duty and they have a power and they have a role under the Constitution, and that duty and role and power is to decide cases and to resolve disputes in a controversy between parties. But they should not engage, the argument goes, in extrajudicial speech, and if they do so, they are in a way misusing their power and violating this way or another the concept of separation of powers. So these are like the most common rationales when one is trying to explain the rule on judicial silence, and therefore comes the question, against the background that Karen was mentioning earlier, the digital age, the era in which there are attacks on public officials as such and on the judicial branch. Is this rule strong enough? Is this rule justified enough? Banning or narrowing or limiting significantly in many jurisdictions, in many legal traditions, the ability, the possibility, the right, even the right of a judge to comment, to react, and obliging her under the code of conduct to remain silent. And in our paper we argue that not necessarily. Let's put it this way, the rule of judicial silence nowadays shouldn't be interpreted that strictly and that narrowly, because there are these reasons mentioned earlier, but also in terms of the reasoning I mentioned earlier by themselves. Let's take, for instance, a judicial image. Of course, it's important, this image, be it the individual image of the judge or the institutional one, but one can really ask whether the judicial image is better taking into account the judicial silence rule. I mean, aren't there circumstances in which the right thing to do for the judge image, for the judicial branch image, is to comment and not to remain silent? In one paper it was argued, and I definitely agree with it, that in a way the behavior of judges quite often in these situations of unfair critique is a selfish one. And why is it a selfish one? Because quite often what they tend to do is to let things go on, wait away a day or two or three or four, and all what they want to do is to go back to business. But in the reality of the digital age, where these allegations stay out there, sometimes forever, if they stay without a reply, it might be that they actually they weaken and they are posing a problem to the judicial image for the future. And it might be that the right thing to do is not to leave these false allegations just out there without any reply. If we talk about the appellant review, I mentioned earlier as one of the rationales as well, then of course it's a problem when judges add reasonings to their original judgment. But then we tend sometimes to find another problematic conduct that is the one that also Karen was mentioning earlier, where judges, because of the rule of judicial silence, are using a later case in order to explain their previous decision. And why do they do that? Because sometimes that's the better way to do, because of the rule of silence. So as long as they are speaking out in another case, then it's okay. But the question is, can this be justified? I mean, isn't that artificial, that when judges want to comment and to react to critique over their previous judgment, the way to do that would be in a further or later case that had nothing to do with it, perhaps. And the parties of that later case may ask themselves, why do they need to take upon their shoulders the burden of that judge has to explain his previous or her previous rulings. If we go again to judge recusal, the law on judges disqualification, then of course I agree it is an important matter and judges should avoid basis for judge recusal. That's obvious. But even in the law of judge disqualification, there are many distinctions that can help us and not necessarily cause a situation of judge recusal, even in an extrajudicial speech. We can use distinctions like when judge refer to the merits of the case or to other circumstances, when it's a pending or impending case or a case that was already resolved. And they don't have to be ex parte communication. They can be made publicly and the parties can know about and even refer to them. So the law of judge disqualification by itself, I think, is not, sorry, it's not strong enough, I think, to explain a strict rule of judicial silence. And if we move to the separation of powers, which was the last rationale I was talking about, I think it's quite a narrow reading of the separation of power concept to argue today that judges need only to adjudicate and have no other powers but this one, because we do know that judges can write law review articles, they can speak in public in conferences, and when we usually talk about separation of powers, we talk about intervening in other branches' activities, be it the legislature or the executive branch, but not necessarily when judges experience or take a position in an extrajudicial speech. So by itself, I think that the rationales underlying the judicial silence rule are not strong enough to support such a strict rule in the digital age. It might be also that that is one of the reasons that, that there are some code of conducts that are already today, ethical codes of conduct, that already today are making this change and weakening the rule of silence. And if I go back to the ABA Model Code of Judicial Conduct from 2011, already in 2007, there's an important section added to it, and I quote from subsection E, subject to the requirements of paragraph A, a judge may respond directly or through a third party to allegations in the media or elsewhere concerning the judge's conduct in a matter. So we do see already a certain change. This specific provision, by the way, was not adopted by all the states. Some of them did not adopt it. And it's yet to see if they will adopt it. But that's a change. That's an important change in the US Code of Conduct on States one. And I think that later on, other jurisdictions around the world will need to face the question whether they do maintain such a strict rule on judicial silence, or that they will go ahead and make these exceptions and more common in order to enable judges to respond to unfair critique or cyber intimidation. And I would add to it that perhaps this change and weakening of the rule itself needs to be done also for two further reasons. One of them, we should keep in mind that judges do have also civil liberties and basic rights, including freedom of speech, and it is known that these freedoms and liberty can be limited in certain circumstances, but the right is still there as a basic one. So that's something I think we should keep in mind. And the other one is that the judicial silence rule, another justification or reasoning for it was the fact that there were alternative mechanisms that were enabling the judge to remain silent because there were other mechanisms that were answering or replying to unfair critique instead of her, be it an institutional reply, court spokesperson, etc., or the bar, their ethical obligation or duties on lawyers to respond to unfair critique. But I think that in the reality today of the digital age, as Karen was describing it might be that these institutional or alternative ways of commenting are not as strong as they were before. And this leaves, again, the judge on her own, trying to face this unfair critique. And therefore, to sum up my argument or our argument, we do think that the code of ethics in the different traditions need to go through a change in order to enable the judges to protect themselves in the end of the day. Karen.
I think, in a word, as we all know, from the particular to the general, normative frameworks cannot be divorced from context. And there's been an evolution in other areas. I talked a lot about judges and the use of social media. Initially, the idea was that judges cannot use social media. And then people realized that this is, a basic form of communication, and that the rules do need to evolve. And I think in this particular context, we've talked about democracy potentially being undermined. We've talked about erosion, which is a component of it, of respect for courts, marginalizing already marginalized groups who will perhaps be chilled from becoming judges, given the potential for humiliation. Must, and worse, must the ethical rule of judicial silence be tweaked in order to allow judges to react in certain circumstances? The answer, as you have seen, is nuanced and complex, but it certainly is moving in that direction. The justifications for judicial silence, as we've seen, are weaker, much weaker today, and it is perhaps plausible and preferable to cope with certain kinds of cyber intimidation by allowing judges to defend themselves in a way to restore what Nissenbaum has, of course, called contextual integrity. This needs to be refined with judicial training, and above all, as I think you had ended the paper, common sense. So thank you all for your time. We won't say more other than in response to your questions.
It's very interesting. Look where